Take a look at this. Ripple's CEO updates on SEC case as XRP whales go on a buying spree. The chief executive officer of Ripple, Brad Garlinghouse, has expressed his disapproval of the Securities and Exchange Commission's stance on XRP. In addition, market figures indicate that significant cryptocurrency holders are shifting their positions currently. The comments made by the CEO come at a time when Ripple and the SEC are engaged in continuous legal fights, and the actions taken by the regulator are attracting the attention of industry experts. On X, Brad Garlinghouse voiced his dissatisfaction with the recent actions taken by the Securities and Exchange Commission. He made the following statement: "A new low for a renegade agency most people thought couldn't sink any further." Despite a court's decision that XRP is not a security, the Securities and Exchange Commission, SEC, now claims it may operate beyond the law. The comments made by the CEO are illustrative of the continuous conflict that exists between Ripple and the government agency, which has been the subject of a great deal of discussion within the cryptocurrency industry. Additionally, Garlinghouse noted that the Ripple team would be watching closely and evaluating our own alternatives to hold the SEC accountable. The SEC is the Securities and Exchange Commission. This comment gives the impression that the corporation is considering taking additional legal or strategic moves as a response to the SEC's strategy for controlling XRP. The market data reveals that there has been a boom in the accumulation of XRP by significant holders who are widely referred to as whales in the cryptocurrency field. This is despite the fact that the legal landscape is still murky. An SEC case over the sale of XRP tokens is being pursued by Ripple, who has filed an appeal on a cross appeal. In an ongoing litigation, Ripple has filed a cross appeal against the United States Securities and Exchange Commission. The business plans to document all of the case's relevant legal issues. Following pressure from the SEC, this measure was implemented this month. He began the process of filing an appeal notice. The cross appeal was filed by Ripple Labs via its CEO, Brad Garlinghouse, and its executive chairman, Christine Larson. Securities and Exchange Commission appeals, second stage. August ruling by Judge Annalisa Torres that XRP tokens traded on secondary marketplaces by Ripple were not securities. In December 2020, the United States Securities and Exchange Commission began legal proceedings against Ripple on the grounds that the business had sold securities without proper registration. The lawsuit has become a hot topic in the Bitcoin niche during that time. The public offering of XRP sales by Ripple to other countries did not violate the United States securities laws, according to Judge Torres's judgment from August 2023. In contrast, a $125 civil penalty was levied against Ripple for purchases made by financial institutions. Although this was a considerable reduction from the $2 billion that the SEC recommended, it was still a substantial increase above Ripple's $10 million request. Ripple opted to pursue a cross appeal following the submission of the notice of October by the Securities and Exchange Commission. Stuart Alderati, Ripple's chief legal officer, said that cross appeal will help make sure that important issues like the definition of an investment contract aren't missed again. Ripple is still fighting the SEC's claim that XRP is a securities offering, and the business is responding to the SEC's appeal with further objections. On October 10, 2024, Ripple responded to the U.S. Securities and Exchange Commission's appeal from earlier this month with a cross. This specific legal battle has not yet concluded. Along with the filing of this cross appeal, Ripple has effectively joined the SEC, and their cases will now be handled as one. The government's decision is being challenged by Ripple. Ripple is seeking to overturn the court's decision that the selling of XRP to investors did not breach any securities laws in its cross appeal. The court's decision that ordered Ripple to pay $125 million to investors for XRP was the impetus for this movie. The CC had originally demanded $2 billion, so this penalty is a considerable reduction. Yet, it is still far higher than Ripple's $10 million offer. As these events continue to unfold, Stuart Alderati, chief legal officer of Ripple, posted a post on X, formerly Twitter, that captured the attention of the cryptocurrency industry. According to a post by Alderati on X, the CC has apparently filed an appeal as it was unsuccessful on all the relevant grounds to ensure that all elements of their legal disagreement with the U.S. Securities and Exchange Commission have been handled. Ripple recently filed a cross appeal. In contrast, Alderati believes that the SEC may contend that XRP's sale on several exchanges and its distribution to developers and workers should be considered securities. The prior court's ruling gave him faith in Ripple's chances of success. And he's crossing his fingers that the current court would reject the Securities and Exchange Commission's recent efforts, especially those spearheaded by SEC Chair Gary Gensler. Following these developments, Brad Garlinghouse, CEO of Ripple, claimed that the U.S. Securities and Exchange Commission is less interested in developing clear regulations for the cryptocurrency industry and more interested in trying to cause problems and uncertainty inside it. Moreover, he declared, "We have been looking towards sealing the fate of the SEC by ultimately putting an end to the Second's program of regulation by enforcement with today's cross appeal." The XRP cryptocurrency's parent company has declared its intention to launch a cross appeal in the case initiated by the Securities and Exchange Commission C2, a hire in a petition filed with the U.S. District Court for the Southern District of New York. In particular, a crucial step in the legal procedure, as outlined by the Court of Appeals for the Second Circuit, is for the petitioner to notify the court and the other party that they intend to appeal a portion of the court's judgment. To ask a higher court to consider a case is to file a cross appeal. It differs slightly from a standard appeal, though, in that it is filed in response to the other party's appeal. When one side files an appeal, the other might reply with a cross appeal. Both Ripple and the SEC are appealing the ruling made by Judge Analisa Torres, who was a district judge for the Southern District of Newark in the past. There are 13 federal appellate courts that examine decisions made by lower courts. The Court of Appeals for the Second Circuit will be in charge of the appeals. According to Stuart Alderetti, Ripple's chief legal officer, the company has taken all necessary precautions by filing a cross appeal today. As part of the cross appeal, Twitter user X argued that a contract containing fundamental rights and duties is necessary for an investment contract to exist. The SEC will not be appealing the determination that XRP is not a security, as Brody and Alderode attest. The chief legal officer of Ripple even went so far as to say that the company regrets classifying the token as a security. According to Alderetti, the CSC may try to rebut the ruling that the programmatic XRP sales and other disbursements by Ripple did not constitute securities, but he believes the SEC will bomb on this issue again. The U.S. Securities and Exchange Commission also sued Ripple Labs in 2020, claiming the company had made $1.03 billion selling XRP tokens, which the SEC claimed were not registered securities. Legal action has been taken against Christian Larson, co-founder of Ripple, and Brad Garlinghouse, CEO of Ripple. In August 2024, Judge Analisa Torres made a divided decision that could lead to the classification of direct institutional sales of XRP as potential unregistered securities offerings. Nonetheless, this category does not include programmatic sales or other distributions like those made to compensate developers and employees. Retail investors didn't know if they were buying XRP from Ripple or another vendor, which is why the decision to prefer Ripple for programmatic sales was made. This means they failed the Howey test, which requires them to have reasonable expectations about the company's ability to generate profits. A total of $125 in fines was ordered to be paid by Ripple Labs by Judge Torres. An estimate of these fines was made using the funds generated from the direct selling of XRP institutions. Trading advice should not be construed from the data that has been supplied. Any investments made relying on the information presented on this page are not our responsibility.